Sarasota, Florida. I've been practicing 23 years. I'm a Stetson graduate. While I was at Stetson, I did both moot court and mock trial. Also did a bunch of, opening statement, closing statement competitions. As a practicing attorney, I've also helped with both the moot court and the mock trial teams with various practices and coaching. Have also judged the national pretrial statement competitions and international law competitions that have been hosted here in Sarasota at Stetson University, not here in Sarasota, there in Gulfport at Stetson University, which isn't very far. I was told that this was only about opening statements, and then she just said something about opening and closing. So this is news.
No, this is only about opening statements. We have a continuing series over the next month that will also touch on closings. And at the beginning of April, we have an open close competition. So that's what we're gearing up for.
Gotcha. Okay. So the biggest thing on an opening statement is it is presenting to the jury, who is your audience, or it could be the judge, presenting to them what the case is about. The biggest, most important thing is to be able to tell the story of your client's version of the events in a way that's simple, concise, to help the jury understand your theory of the case. A lot of times it's always pushed to have a theme, and a lot of people go really crazy trying to come up with a theme, and it kind of causes a roadblock in their ability to go any further because they're trying to think of some fancy theme for it. And not all of them, do the gloves fit type thing happen in every case. In fact, usually you can't find a fancy theme. So the easiest way to come up with a theme is to try and talk to, let's say, your family members and try and tell them in one sentence what your case is about. Well, let's see, my case is about intervening causes. So let's say you're driving down the road and a truck barrels into you, starts to barrel into you, and the only thing you can do is pull over into the next lane, and it causes another car to ram into you, or you to ram into another car. So those are intervening causes. So that might be the theory you want to go with. It can be, you can say it can be about carelessness, if you're on the other side, somebody wasn't paying attention because they were texting, or it can be about greed if it's, a theft case or an embezzlement case. But whatever it is, it needs to be concise in a small thing, and it may be something that you repeat. So if you can have a really catchy thing like this case is about carelessness, you may want to repeat that a couple times through your opening statement because it will drive that home. However, you're going to get that one word or phrase to be your theme, and then tell a story that hits on all of the elements that you are responsible for proving. And you're going to tell it from your client's perspective. So you put them in an order that it would only lead to one conclusion. However, you have to be careful because a lot of people make the mistake of arguing in an opening statement, and there is no arguments. I suffered with this a lot because a lot of people don't understand what argument is. Argument is coming to a conclusion, saying this evidence will show you this, this, and this. That's a conclusion, and that's drawing the line. But you can say, we will have evidence that shows this, or you'll hear from Ms. Smith who will testify to this, and let the jury put those pieces together of what that conclusion will be. But you're going to say it in such a way that if you heard those facts, that's going to be your natural conclusion. You also need to make sure to personalize your client when you do this. So you're not going to call your client the defendant. You're not going to call and if you can avoid it, if let's say your client's a corporation, avoid calling it, the company or something like that. Do call it by something that personalizes it. Reference the main characters, like Mr. Smith owns XYZ Corporation. So you can then refer to it as Mr. Smith's company. So you've just personalized it for them, because a lot of people have businesses, but they're not a big corporation. So if you can find some way to personalize that so that the jury can identify with them. Now, when I say identify with them, there's got to be careful on that too, because there's something called the golden rule. It doesn't matter if it's opening or closing, you can't violate the golden rule, which is tell the jury to look at the case through their eyes. Put them in the position of the defendant. I remember the case, A Time to Kill. It had, let's see, McConaughey, I can't even think of all the famous actors' names in it. Anyway, and this one was a case about a Black man who was being charged with the murder of somebody, and he murdered the people who raped his daughter. And what McConaughey did was he had the jurors close their eyes and he put them through the whole thing that the guy's daughter went through. And then at the very end, he says, now imagine that she was white. And so it got all the jury going, oh yes, I can imagine now that, you would, want to come after the killers for that. But the point is that would have never been allowed in real life. You can't do that. I mean, it's great for the movie, but not in real life. You can't do anything that will cross that line. You want them to identify, but you don't want them to specifically tell them to be in that place. One of my biggest pet peeves is hearing students say the evidence, or even attorneys, the evidence will show. Because sometimes people will repeat that over and over again. The evidence will show this, the evidence will show that. Well, at that point, the jury's going to start turning you off because you've repeated a phrase. And second, the evidence may not show that. So you have to do it more of a story thing so that it doesn't hit you in the face if the evidence doesn't quite show it that way. The biggest thing that a jury is going to look for is not only what you think the case is about, but they're going to, like, if you're the plaintiff, what you're doing is you're creating an accusation. This is our accusation. And the defense then has to rebut why that's not correct. So they're going to look to see how those play up together, and not to mention whether those facts that you're alleging actually are shown. Sometimes you're confronted with a case that has bad facts, or something that you will hurt the jury's opinion about something. Like your client was previously charged with child molestation or something like that. And you don't always know if the other side's going to use that. So you have to kind of make a decision whether you're going to hit it right at opening statement saying, well, you're going to hear that Mr. Smith had been accused of embezzling once before. Or you can choose not to say anything about it. But you have to kind of weigh it. Now, if you are on the defense side, it's best to wait and see what the plaintiff is going to say, because sometimes they don't know how to put it out there, or they don't choose to say it yet. So if they didn't bring it up in the opening statement, usually you don't, as on the defense side, you don't want to bring up that bad statement because you don't know how it's going to come across at trial. It may not sound quite as bad at trial, or it may not even be brought up at all. So you don't want to present that to them and have them thinking, is this important? If for some reason you feel that you need to address it in an opening statement, make it very quick and run through it. Don't harp on why that's not a good bad fact unless you can somehow say, well, they'll tell you how this, but that was because of blah, blah, blah. One sentence, because you don't want that to be their center focus. If you're on the plaintiff side, not only bad facts against you, but you also have to think ahead for possible affirmative defenses, because you don't know what affirmative defenses are going to be part of their opening or what they may or may not bring up. So you have to be prepared to argue why those defenses wouldn't apply. Because what's going to happen is you're going to lay your case and say, the case of the guy in the driving down the road. So you're the plaintiff, and you were rear-ended by this lady and you didn't see anything else, you were just rear-ended, you were hurt, you now have severe pain. And so the jury hears about how, you know, she got rear-ended by the defendant and she's in so much pain she can't move, and she's gone to so many different doctors, and they say that she's going to have spinal surgery and she will probably never be able to walk again, and her daughter died in the car. You know, I mean, all the bad things you could think of, right? And then you hear the defense side, you know, the jury hears the defense side, and the defense side says, yes, the defendant was driving along, and then this car came out of nowhere and coming right at them, and in a blink of an eye, they had to swerve, and they swerved over into the plaintiff's car. So that's the intervening thing. So the jury's going to say, well, how come they didn't mention that? That's going to give them pause, because the defense is going to spend all this time talking about this thing that caused them to not be careful. So you have to address it. That's something that you have to maybe address as a plaintiff, saying, now you're going to hear that there was a truck, you know, that caused them to swerve over to the other lane. However, you'll also hear testimony that the defendant was texting at the time. You're not going to say anything more. You're not going to say that she was texting and therefore not looking, because that's drawing a conclusion. You're just going to throw it out there and let the jury go, huh, yeah. So let them draw their own conclusion. So it's really important, especially when you're on the defense, to listen to exactly what the other side says so that you can rebut anything they say. I can't tell you how many times I've, both in practice and in judging competitions, that you feel like you're hearing two different cases because they don't even, one never addresses the other side. And so it really confuses the jury and it makes them not trust you. So the more you can give them that will be on point. So don't exaggerate, don't add too much, don't promise them something that you can't deliver. So if you're not sure how it's going to turn out, don't say you're going to hear this, because they might not hear it. But if you're fairly positive, it's like your client's going to testify, you're fairly confident that's the testimony, or your star witness who's, you know, a good friend. So another issue that I see is people getting caught up in technique. So people will hear examples or read examples on opening statements, and they'll think, well, I've got to, it's sort of like the theme concept. I have to do something like that, and they'll get caught up in somebody else's style. Just be yourself. The whole point of this opening statement, here's the main points of what you're trying to do. You're trying to introduce the jury to your version of the events. You're trying to get the jury to, most decisions are made within the first 10 minutes, just so you know. People have already, not 100% decisions, but they really have an inkling for where they're at, is that first introduction. So have them feel something for your client. If you have a client that's not really personable, find a way for them to identify in some way with the situation your client's in, because you want them to be compassionate towards you and towards them. And then keeping it very simple. If you add too many characters or too many facts, like I've seen people try to kind of put all the facts that are going to be in the trial into their opening statement, and the jury fell asleep 10 minutes ago. It's too much. They can't remember all the characters. They can't remember all those facts. Keep it very, very simple. And then fourth, make sure you ask them what you're wanting. So you might give them the story of what happened, and then you'll say, ladies and gentlemen, what you need to decide today is you need to look at the evidence and see that the evidence did not show you that you know, Mr. Smith did this, and that whatever the elements are, and therefore we're asking that you find the defendant not guilty, or, you know, whichever side you're on. So make sure you give a little quick synopsis of what it's about and what you're asking for. Don't sit down unless you have. Some people waste a lot of time talking about details of who the parties are. Again, I really think it's counterproductive. You should come right off the bat with something that's going to grab their attention, whatever your intro phrase is or your theme is, and then take them through the storyline. It's very easy to lose that jury right there, right off the bat. So don't get caught up in what you think the other side's going to say unless you absolutely have to address it. It's also good to move around. So let's say you're standing there at the podium and you're going to make a point. You might at that point walk forward, not too close to the jury. And it depends on your judge if your judge allows you to move around. Some do, some don't. But that's when you might move a little bit closer to the jury and say whatever that major point is, because then it all of a sudden, someone who was dozing all of a sudden notices, oh, something's being said that's important, because you walk forward, you did some sort of movement, or touching on the desk. I'm not saying pounding the desk, but touching on the podium and saying, because he didn't, that's why. The other side of that is you don't want too much movement. You don't want to distract with all of these hand movements or anything. So if you're someone who talks with your hands, that's something you should practice, is maybe keeping them on the I don't know if some courtrooms have you at desks, some have you go up to the podium to stand, but if you can, I prefer standing at a podium because I was trained that way, but I just hold on to the podium so that I can control my hand movements. Trying to think of what else I may have missed. Memorize. Now, even if you're on the defense side where you have to put in, like, respond to maybe something that they said during the plaintiff's opening statement, if you have your story memorized, that's why don't make it too complicated. Keep it simple. What is the story? What happened? And why do you think it should be from your side? When I remember when I was in law school and I was practicing for an opening statement competition, and I had my son, Rachel's older brother, keep time for me. And so he was hearing, and you have to be able to do both sides. You flip-flop back and forth arguing plaintiff and defendant on those competitions. And so he heard the first side and then he heard the second. He said, "You lied." And I said, "What do you mean I lied?" He goes, "No, that's not what you said before." It's like, it's the same facts. I haven't altered them. It's just someone else's version of how you should look at them. And that's exactly what you're doing, is you're giving the same facts, your spin on it, seeing from your client's point of view. So if you get that down, don't worry about missing a particular point or something like that. Maybe keep an outline of major points that you want to make sure you say. If there's something that you definitely want to make sure you say out loud, write it in some bullet points on a piece of paper. But otherwise, if you're just standing up there reading what you're talking about like this, you're going to lose everyone's interest right off the bat. Now, I know I talk really fast, so I don't know if I've lost anyone or if anyone has any questions. Any questions?
I think they're used to me talking fast.
That's my spiel. I don't know what else was being expected.
No, you did great. Thank you so much. I thought that was really insightful. Does anybody have a question for Ms. Sams? Since she made time in her day for us. I thought you were very clear with what you said.
To all the 1Ls who are looking to try out for the open and close competition, this is your chance to ask somebody who's very good at it.
Crickets.
I'll jump in and ask one. I'm Jesse.
Okay. Hi, Jesse.
I'm the 3L, by the way. I'm a VP. You did a great job. Hit on a lot of stuff. You touched on the golden rule. Thank you for doing that, because that's one a lot of 1Ls. To those of you listening, make sure you don't do that. I do have a question though. So I was taught some hand motions, resting, open, and then together. Would you recommend those, or do you have any thoughts on what to do with your hands if they're not on the lectern?
Whatever, I've never heard of that. whatever works for you, because if it's something that you're forcing, it's going to come across really stiff. So I hold the Laturon only because I tend to talk with my hands. Sometimes it's fine. Sometimes it's fine too. It depends on who your audience is. So if you have a jury, and so you can do a little bit of striding, that kind of helps. Having your hands open is very helpful. Pointing, showing your client, touching your client, walking behind, putting your hand on your client. Those are all good things to personalize your client for you. And, or if you're the plaintiff, being accusatory, pointing at the defendant, just with your arms, being accusatory. Those are motions that are natural and may even come naturally. Where it becomes a problem, it becomes repetitive. When people do repetitive hand movements or repetitive movements like back and forth, then that becomes distracting. If your audience is the judge, very different. You're not going to move around. In fact, you're going to hardly move at all. And you're going to stand at the turn and make your argument. You're also going to include more law. So if your opening statement, if it's a judge by a trial by a judge, which 90% of mine are, those cases you're going to kind of stick with the facts and how they relate to the law on the case. But you're not going to do that with the jury. You're not going to hardly even touch on the law other than to say maybe what the elements are. Don't get into burden of proof so much unless it's a criminal case, because the jury's going to be instructed at some point what the law is, and it's too soon, and you have a limited time to have them make up their mind. So you want them to make up their mind during that opening statement. And don't talk to just one juror. You may have one juror nodding and going like this. Don't assume that that's the juror that's on your side, because sometimes it's not. Make sure you make eye contact with each and every juror. So you're going to take them one by one, not show favoritism or anything. Kind of answered that question.
Absolutely. Thank you.
I have a practice tip question.
Mhm.
It is best practice to have your opening memorized, but for somebody that's not used to public speaking, what is your like if you get lost or in the weeds in the middle of it, do you have a practice tip for kind of getting yourself back on track?
Well, I'll tell you, in practice, you're not going to have all that time. I mean, most of your cases, unless you have a really big case, most of your cases, especially if you're doing criminal work where it's boom, 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 you're not going to have time to do all that. It's going to be by the seat of your pants 90% of the time. So that's why you have to know your facts. So make sure you know your case. You're going to have to know it for trial. So make sure you haven't relied on an assistant to do your research or to do all your interviewing. And if they are, you've read through those 2 and 3 times and maybe your assistant also read through them, or your associate that you're working with, and then discuss it with them so that you know all your facts intimately, so that if you get out there and all of a sudden your brain goes blank and you don't know, because you know your case. So you can just start talking about your case. It doesn't have to be that memorized argument. And I have to tell you, I can't remember the last time I memorized, and other than closing, the last time I've memorized a whole thing for anyway. So because there's just no time to do that in practice in real life. Now, I imagine if it was an extremely big case, I might feel differently about that. But for the most part, I just get up there and it's a conversation. It's just, this is what this is about. This is what we're going to show you. You're going to, hear from this and this, and you keep it simple. And people appreciate that.
Great. Thank you so much.
I have a quick question. My name is Wesley Ecke. I'm chair of this committee of education. I'm the one who usually puts these on, and I thought this was a good way to get some engagement out there. But I'm more of a theatrical kind of guy. I like to, everybody's rolling their eyes, and everybody's seen me do it. I'm big on theatrics. So I guess, what is your opinion when it comes to opening statements on how, I guess, big you want your personality to be when you're giving an opening?
Well, here's the problem with that. If you make you the center, then the jury, you're having the jury make a decision based on whether they like you or don't like you. And as a insurance company rep once told me when we were in mediation, she has seen juries go against somebody because they did not like their cowboy boots. Seriously. So you don't want it to be too much that you are distracting from the story. Now, if it's a really bad story and you have no hope in heck to win, then maybe you want that to be a distraction. But for the most part, you're going to want to plead your case. And if you're not pleading your case, otherwise you're just selling yourself, which, I mean, you may be a really good salesman and you may be somebody the jury really likes, but on the other hand, you may not be. And it may be some people in the jury that will turn off. That's the reason why in the beginning we try to, keep it a little bit more simple. I do know a lot of attorneys in certain areas of law. I guess you find them more in torts that are going to, and maybe criminal defense. They're going to be more pulpit pounders and get a little jumpy up there. There's really nothing wrong with doing that in that setting, with being a little bit more theatrical or a little bit more dramatic in your speech. There's really nothing wrong with it as long as you don't overdo it so that you're overshadowing things, because you want to be persuasive and you do want to talk to, get the jury to understand. And if that's what it takes to get them to understand, you just have to maybe get feedback from somebody on whether what you're doing is overdoing it or not. And every person's different. There used to be this attorney that their family dedicated all the courtroom or a bunch of courtrooms in Stetson. So he was well beloved, alumni. They came to show us some examples. And this guy talked with the smoothest Southern accent that he could have said, and I stabbed your mother's eyes out. You would say, oh, thank you, because he could just talk. He was like butter the way he talked. And so some people can get away with saying outrageous things because of their quality of the way they come across, whereas another person can't get away with that. So that's why I said it's got to be unique for you. Don't try to make yourself somebody else. You're not going to do good just standing up there, giving the recital of the case. You're going to be a little bit more enthusiastic about that. Try to remember the case that was just a recent case where somebody started off, the Zimmerman trial. Remember the Zimmerman case? I guess it wasn't that recent, but that person who was charged with the murder of, I'm sorry, I can't remember the other person's name, but at any rate, he started off his case with telling a knock-knock joke. So trying to relax, it got the jury's attention. It was a dumb, corny joke, but it got the jury's attention, so they pay attention to him. If it worked, I mean, that wouldn't work for me, but if it works for you, it works for you.
I have a question that was submitted to me from a shy audience member. She asks, what do you recommend for 1Ls that are doing this for the first time? Do you have any specific materials that you would recommend that they use to start looking into this? Or anything to watch?
I have no idea what's out there these days. No idea at all. And I don't know what your school does. At Stetson, at the beginning of the year, they're already in their second semester now, but for the 1Ls, but at the very beginning of the year, 1Ls, they put out their competitions, just opening statement and closing statement competitions for 1Ls. And and I had a horrible fear of authority figures, a horrible fear of it. And I just thought I couldn't do it. But that's what pushed me through it, is forcing myself to do that over and over again. Constantly putting myself out there is what got me through that. I know Rachel has the same issues and she seems to have done okay. But just the more practice you have doing it, the better the more comfortable you are. Still get nervous going to court to this day, but the more you do it, the more comfortable you are. And so if it's practicing those statements, if they're trying out for mock trial, practicing all of those things in front of, their family members. Now, do you guys do it as a full trial that is the part of the trial for trying out for mock trial, or how do you do that?
So our 1L competition is just an open and close. We hold it in the spring of their first year. And then in the fall of their 2L, or well, I guess 3L is a little bit late, but mostly 2Ls, we have a full intramural where they give the whole shebang. So, but for 1Ls, it's just the open and close.
So there's no opportunity to compete other than if you're trying out for mock trial. You don't have any intramural mock trials for people who don't want to be on a team, don't want that extra time, but they want to try that. There's nothing like that?
That is something that we're starting to kind of work on. That's what this series on Thursday, we're inviting everybody back to try to workshop an opening and give it in front of people to shake off those nerves. Our mock trial team is still pretty new, so we're working out the kinks. And that's why we're hosting these new programs.
We have a fall intramural competition every year. Started 2 years ago.
Yeah, and that's what I mentioned for 2Ls and 3Ls.
So if you don't have access to something more for those 1Ls, like I could say is practice those, go through these workshops, practice on your fellow classmates, and practice on your family members, because they're potentially a juror. They can sit there and tell you how that works for them or doesn't work for them.
I picked up this book. This is our course material for the mock trial course. It's pretty good. Thomas Mawe, Trial Techniques. If anyone is looking for something to read to help out with this. Have you ever seen this, Ms. Sams?
Not that specifically, but I mean, I know we had books like that when I took trial ad in college, but I don't remember specifics about who they were by or what their title was or anything. And I don't know. Yeah, I guess they were helpful. Now that I think back, I guess they were helpful for, especially as you got further on, not just opening and closing, but just how do you introduce evidence? I mean, I understand what the rules are, but how do I do that, strategically in court? What do you have to say and everything? So those were helpful for those reasons, because they actually would step-by-step walk you through how to do that.
If everybody is also looking for, I guess, materials as to how you can learn how to give one, or what one specifically looks like. Again, Sarah said it best in the chat that YouTube is your friend. There is an opening statement from the Zimmerman trial that I use in the materials that I use to teach this. It's how he enters in and starts the trial. He basically uses George Zimmerman's words, and the words were very bad. And it's just things like that. Just things that you're able to use to stick in the jury's mind. It's just it's all style. Everybody has their different style. So if you watch videos and you see a number of opening statements and you can just craft your style, it's like a kind of a puzzle piece kind of deal. That's how I did mine. That's how I learned my style. So it just depends on everybody. So go to YouTube. It's your friend. If you have any questions, ask me. I'm here, and I've been doing this for a little bit. So.
Any more questions, either in the chat or directly?
I have a question.
Yeah, go ahead, Grant.
This is Grant Klingler. I'm a 1L. So I know you've mentioned that you, as individuals, we want to find what we're necessarily good at, not go outside of our comfort zone to try and do other things, but to find what we excel at. So in going off that, are there any times where you may adjust your techniques? For instance, something simple like maybe you're a very friendly, smiley person, and you usually make your opening statement with a smile. Is there any circumstance where maybe you have a feel for the jury is a little more, against the smiley? Or is it one of those things where you want to continue on with what you do, what you're happy with, what you're used to, or do you want to try and make adjustments. I can see it going both ways.
I think you're going to want to adjust that a little bit. It depends on the circumstances. I mean, I don't do wrongful death, so I haven't ever had to encounter having to make the jury just be shocked by, you know, the circumstances. But I mean, I could see that you're not want to go in there and, you know, be all smiley talking to a jury about wrongful death, nor do you want to be all, you know, quiet and laid back in talking about something that's a very dramatic situation. So don't try to be somebody you're not, but that doesn't mean you don't push the envelope or go out of your comfort zone ever. You'll always be out of your comfort zone. 90% of the time when you practice, you're going to be put in a position where you're not in your comfort zone. That's part of the law. It doesn't matter whether it's you're trying to write a contract or you're trying to, you know, argue before a judge. You're going to be put in all kinds of situations on a daily basis where you're put out of your comfort zone, which is why we chose the laws, because it's so versatile and it's so challenging. It's constantly changing. So I apologize if I gave the impression that you shouldn't. I just don't want you to try to be somebody you aren't. So don't go out there cracking jokes to the jury if you're not that personality, because they're going to see it as a fraud and they're going to assume your client's a fraud. Don't go out there and try and be, you know, someone who's witty or has that special theme or something if it sounds makes it sound choppy. Likewise, if you're trying to be somebody else and you get that, like Brittany was talking about, where you get the you know, brain fart in the middle of it and you forget where you're at, it's going to be hard for you to go back into character if you're being somebody else. But if you're being yourself, I mean, you can be happy and you can be sad, and you can be, I mean, us as people, we have those different parts of ourselves. So you could be talking seriously about something or differently about something. I'm in a meeting. I'm in a meeting. My IOTA account. Sorry. Where was I saying? Anyway, so you want to be able to fall back into it. You don't want to have to, I mean, for the sake of these competitions, you could probably do a lot of things, because you guys are going to have weeks to practice for things and you're going to go over them 1,000,002 times, but in real life, it's just not going to work that way. So that's why I say keep it to what your personality is, because that's going to make it easier for you to get up there with less nerves and be able to not have to rely on a rote memorization of a speech. You can get up there and talk natural language, and that natural language is what sells it. That's what sells it.
I know for me, whenever I started doing mock trial back in undergrad, I used to be this hard charging, you know, the hammer kind of guy. Like they said, every toolbox had a hammer, and I was that hammer all the time. So eventually my coach had to pull me aside and listen, you know, you're going to lose a lot of trials because, you know, you're not adjusting to the case, or you're not adjusting to your audience. So you need to, you know, find a different way to, you know, shift, you know, via the case or whoever. And I had to learn that. And I've calmed down as I've gotten older. So, you know, it's something that, you know, it's trial and error. That's all it is. So.
One more question from the chat. Chantel is asking, how has COVID changed your trial technique? I guess especially with your opening.
Oh, it's
I'm
horrible.
talking to the screen.
It's horrible. I mean, it's great because you don't have to travel anywhere. And so I save a whole lot of time parking and walking. I don't have to worry about the rain and all that. But I think women might identify with this more than men will. But, you know, before you were in a courtroom and you're like this to the judge, that far off, or the jury, that far off. Whereas now, this is what they're seeing, and it's your whole face. And so you're far more conscious of your appearance than I ever was before. I mean, it makes you really kind of nervous. On the other hand, you know, I can wear jeans. No one knows. As long as my, you know, I have a jacket on or something, I'm good. I think it's harder. it's harder to be persuasive because part of the way I was trained is that movement means everything. How you talk to the jury, and you're talking to each individual juror, and you're looking at them, and you're moving your hands, and you're walking, and you're setting something down, and you're making a point. It's hard to do. Now, imagine if I set up a camera in a big conference room and had me far away, I could do that. But I think that's still hard because then I'm just this little person. I haven't found a happy medium, but I have for trials or major evidentiary type hearings, I am not a fan. Not a fan of the Zoom.
Do you have any recommendation to, especially in the mock trial sense, for people that might have to deal with, talking to the camera when they're doing these competitions, to kind of overcome that brick wall feeling?
Huh. Are you saying that you would feel like you're talking to a brick wall because you're not getting feedback from whoever your jury or judges are in the competition?
Well, I think that definitely is part of it, right? Because when we're talking to a jury, for example, we're looking for those little like affirmative feedbacks that they're hearing what we're saying, or that they're listening and what we're doing is kind of hitting the right note. Whereas if we're talking to a like camera, the other person is usually silent, or they're just kind of blank face, or sometimes even the camera is off, right? So you can't see their face. So it's just overcoming that lack of human response in communication.
Well, probably a small cheat you could do for your competitions is have somebody on the other side of that camera that you're talking to, so that you are even if it's not from the real people, you're getting some sort of conversational cues back from them. In real life, you get that though. You get jurors who are busy doing crossword puzzles, knitting, sleeping. You get judges who sleep, judges who are there, and I used to clerk for a judge, judges who are playing games with other judges on their computers and not paying attention to anything that's going on. Very, very common, and it's very frustrating. I can almost tolerate that. It's when they're looking at you and there's no facial expression, no response, no anything, and you're like, so do I keep pushing that point or do I let it go? So and obviously this, whole Zoom thing is very new, and I haven't come across where I've been practicing long enough that I'm not needing all of these cues, though I have to actually say I had a hearing earlier today that the judge acted really irritated. I mean, she acted like she's going like this the whole time I'm talking, and I'm thinking, but this is what the law says, and this is what they did. It was a motion to dismiss. This is what they didn't, this is what they didn't, I have no way to respond to this because they threw in the whole kit and caboodle in this complaint, and I don't know what the case is about. And it worked out okay. I mean, the judge ruled in my favor, but I did find, because I don't know what's going on in her courtroom, I'm just seeing her acting all gruff and seemingly responding to me that way. So, I mean, it's a whole new world, and hopefully it won't be for a long, long time that we'll be doing this Zoom. So, but other than that, for your competition, cheat, have somebody on the other side and talk to them, and that.
All right, thank you so much. I appreciate that.
Okay. So are we all done?
I have for those of you who want to come back on I guess Thursday, I think it's Thursday. Those of you who want to come back and actually show your skills, I guess show what you got. I created a little fact pattern. I'm just gonna put it in a document inside the chat box. If you want to do this, that's fine. Just all you have to do is just create 2 to 3 minute open, and then present it on Thursday. Let's see what you got. Try your hand at it. See what you learned. No pressure, definitely. I mean, we're all here to learn. We're all here to get better. So for some of you, it will be your first opportunity to write an open. some of you probably done it before. And that's good. We can all learn from, having different, viewpoints on it. So I'm just going to put it in the chat box. And if anybody wants to do it, do it, come back. I guess we can email it out. We can email it out, but I'll also put it in here too. It should be on YouTube, the recording. Yeah. So if anybody has any other questions, definitely let us know.
Yeah, guys, we have a YouTube page channel now. This will be getting uploaded there later. I have forgotten the name of the YouTube. I just created it this afternoon, so I will send it out with the email that I send to everybody. Yeah, Miss Sams, thank you so much for making time for us
welcome.
today. Appreciate you so much. I guess
Good luck,
that's
guys.
it. Everybody, just
Thank
thank
you.
you.